July.
Okay. Call the meeting to order for the three-member panel hearing of the Building Board of Regulation Examiners and Appeals for May 25th, 2016. Specifically, it's regarding the business of Appeal BCA-02-2016. We have an agenda before us. I'll entertain a motion to accept the agenda.
I'll move to approve the agenda as submitted.
Second.
Any changes or discussions? Hearing none, we'll get an agenda. I know nearly everybody, but not everybody, so if we could go around with some introductions, I appreciate it. I'll start with you, Ron.
Ron Thompson with Scope Permitting and Engineering.
Tyler Loken.
Scott Boney.
John Steele.
Anna Thunder.
Gretchen Steller.
Sam Severin. Ross Knopfinger.
Kent Colhes.
Gary Heil. Hans Giesler.
Thank you. I guess the first order of business would be to consider formally hearing the appeal. And we have a document from the municipal attorney regarding whether that is appropriate or not. Sam, would you like to present that, please?
Yes, I would. And I think it's important to do it at the outset. And I'd like to speak to it. I'll try to be careful not to overlord it in light of the nice weather. But I found, I hope everybody got a copy. I submitted it to TANA for distribution on May 25th, objecting to the board having jurisdiction. Two things I want to note at the outset is, one, I did notice that I was using the old code and that it changed. So I was citing the old code, and there's now, the things that I was citing have changed a little bit since the April, I guess it's April 1st. Mr. Thompson's or Scope's request was submitted some time ago when we were under the old code. For the purpose of my argument, I really don't think it makes much difference, but I was citing the old code and didn't mention the new code. I think if you look at the sections that I cite that are pertinent to my argument, they're materially the same, really. The other thing I wanted to mention just at the outset, and I did mention this in the motion, but maybe I can verbally explain it, is it might seem strange that we convene a hearing and say, sure, everybody show up on Wednesday night and we're going to have a hearing, but we don't think you should have a hearing. And I recognize that that's a bit of a conflict. The reason is, I think it's just hard for the same body, same office that submits a decision or makes a decision to then turn around and be in the position to say, well, you have no right to appeal this. That's just a bit of an awkward situation in my mind. So my advice to this department and others who are in that question of do we accept this appeal is that unless it's just grossly outside the subject matter of what that department does, to just accept it and then later argue to either the hearing officer or a board like this that it shouldn't be accepted. That way it's a neutral party making that decision. At some point in the future, maybe we can come up with a better way to get it to the board for a decision that's neutral without having to all convene. But I just don't want to run afoul of a due process thing where we make decisions and then also just turn around and say, we've decided you can't appeal that. So that's why we're doing it this fashion. So having said those couple of things, just a few other thoughts that aren't really outlined in my motion. I've done a little research, and I try not to over-lawyer this stuff, but I think that one of the things I found is I think Alaska courts are going to do pretty strictly construe whether a board is acting outside of its jurisdiction. They look at that pretty carefully, like what zoning boards are big one, and whether they're ordering things that they have the authority and code to order. And it's my position in this one that the board really just doesn't have the authority to order money damages or money refunds. And one of the other concerns is, I don't think the authority can be found in the code, and making the municipality, in essence, write a check is just not, I think that's an extraordinary remedy that would have to be outlined pretty expressly by code. I think it would be arguably different maybe if somebody were prospectively coming to you guys and saying, the municipality wants to charge me X amount of dollars for these inspections, and I'm not buying that. I don't think that's right. That seems arguably a little different deal because it's not money that the municipality has got in its coffers and is being asked to write a check for. One of the other concerns that I have that's probably, I would imagine, on most people's minds is the precedential value of starting to award damages, or award money refunds. I think we really would be forced to appeal to the court and/or look at putting an express prohibition in the code. Large refund requests like the ones that are at issue tonight, tens of thousands of dollars, are the obvious concern, I think, that comes to mind that the municipality would be concerned about. But I think the little ones are just as important. If we have to convene a board frequently to hear appeals about $1,000, $2,000 type refund things, it could really, I think, blow out of proportion. And on that topic, the other concern I have is that I think all the personalities here tonight are reasonable and we all know one another, but I think if we are to start reading this to say that this board or similar boards have the ability to just issue refunds, and we don't know who's on the board in the future or whatever, that could be it could be a big problem. But primarily, it's just that it would be a pretty extraordinary remedy, I think, kind of like something that a court really can only do, and that lacking the express authority, I'm not sure what other municipal boards, if there are any, that have the ability to order checks to be cut. And the other thing it raises, like in this case, and we can argue this later, timeliness, the statute of limitations in the court system would be 2 years if this were a lawsuit. And what ability does the board have to figure out those types of arguments? It's just, it creates a lot of problems if you're coming in here and asking for a check to be written for large sums of money that there's no express authority to give. So I think that was largely laid out in in what I wrote, and that's probably enough on it, other than I'd be willing to hear from Mr. Thompson or answer any questions.
There is a written policy in there that if inspections go over or if inspections aren't used, an adjustment will be made. If I understand the code as written today, is that not true? That if a contractor went into with a new permit today, oh, you got it right here.
It's in code and policy. That a refund will be given.
As per cancellation, must be more specific to if there is a line in there that if inspections are not used, I'm trying to find it right now, that the contractor may apply for a reimbursement for those unused inspections.
I think 310 states exactly that.
What section is that, Ron?
It's in table 3A. It's been taken out. It's been taken out, or it's actually been put back in by the Assembly again on April 1st when it was taken out, but put back in again. It's in code today and effective today.
I think it's in code. You state that it's in code, your sentence in your rebuttal of these various powers. The only one that is, and you use the word arguably, but that there is one that applies in old code and in new code in Title 23. So it might seem like I guess that, along with, I don't think we have the power to force anyone to do anything, but we can hear an issue. And I think you stated that even in your first sentence, saying, hey, we're here because, well, we say we shouldn't be here, shouldn't have a meeting, but we're here because we think we should. So those two combined right there give me all intents to hear this out. So,
Sure.
Yeah.
give me at least enough reason to hear
Have you
this.
seen this document at all from Ken Coolhouse? Coolhouse, excuse me?
Yeah.
And on MOA 17, page 3750. Excuse me, 25, 58. Right here.
Well, okay. Let me, I guess, make two comments. I'm not necessarily saying that the board can't hear the issue or make some kind of recommendation or something. Maybe it's more accurate to say that I question, and I do not think the board necessarily has the authority to enter an order that's binding on the municipality to pay tens of thousands of dollars at the end of the day. We have every intention to present evidence, go through the hearing. I just want to raise that at the outset and make a record of it.
Do you have any examples of that at other boards? Either doing that or not doing that?
Yeah. Not paying money like that,
Or no, not enforcing, and pushing a decision through a monetary value.
I really couldn't find very many. I don't think it's asked for very frequently. I think usually people, when they want money like that, they go to the court system. That's really what happens. I just don't think it happens very often. There have been examples of this board. What I do have is examples of this board making decisions in the short time that I've been around that it shouldn't hear a case for some reason or another. A couple of years ago, we had a Collingwood Builders one what they were talking about was in Title, it related to Title 23, but it really wasn't a sort of a technical building type issue that is what, it just wasn't the type of thing that the board thought we had the expertise to look at. It had to do more with our internal processes. And another one was the Isabel one that was here recently, and that wasn't so much about money, but it was a question about whether a 2005 building board hearing could be sort of rejuvenated in 2015, and the three-member panel said no. And it was one where we kind of did the same thing. It's like, hey, we're not going to just decline it outright because the board ought to do that. But so as far as money damages type of things, it's pretty hard to just research that. In fact, I didn't have the time. I tried to find out if Alaska courts had said anything on it, and in the limited time I had, it was difficult to find. So
I guess where I was coming from, you said the municipality doesn't refund money, and here's the policy in place where it does, so
No,
I wanted to.
I think the municipality absolutely does refund money in certain circumstances. What I'm questioning is the board's authority to say, you need to write a check for $20,000 for refunds going back over this span of time. I just don't see that. To me, seems much more like something that a court would be doing, and lacking express authority in the code to issue refunds. I mean, if that was what was contemplated, and to referee disputes about $75 refunds, that to me seems like something that really ought to be in here, if we're giving people the authority to order that the municipality take money out of its, you know.
It is.
Mr. Steele?
Just have one question on your document, Mr. Severin.
Sure.
On page 3, you make note that if the board were to award a refund, you felt the municipality certainly would have to challenge the decision in court. And I'm just trying to find the perspective for the appellant. If we were to not hear the case, do they still have a legal recourse to recover it through the legal system?
Yes. They'd be subject to the statute of limitations, but
Would it not get remanded right back to this board? Because the decision-making body.
it wouldn't get remanded to the board, and you wouldn't, I mean, not if we said you shouldn't be here.
It's done, every building board case that I'm part of that went to court was remanded back to this board.
If it were a technical, if it's something that's in your technical area, the court's going to say, hey, look, we've got contractors, engineers, architects, those guys, that's why they're there.
You're going to look at this code right here that says to hear, decide, deal with the decisions of administrative officials relating to building and other regulations according to Heritage Code.
Title 23.
Title 23. So
this code-
that it doesn't get into specifics whether it comes back to us or we have jurisdiction. It right there, you state it, and in your first, couple sentences, you state it again. There is, we can hear the case.
I'd like to read an email too that I sent to the administration today, or this week, when I got the legal brief, because it's like, I wanted to find out, if they didn't want it to go to the building board, I wanted to give them the break, let's go meet and talk about it. I said, Chris, I want to see if you can meet with me in regard to the building board appeal I filed. I see the legal brief and can agree why the MOA would not like to have the BB make a decision on it. I'm willing to discuss it with you and the municipal attorney, go over why I filed it and how the MOA did not do as they were supposed to. I do not know if you know about it, but I would like to meet with you and the MA before Wednesday so I can drop the appeal based upon this meeting. Maybe we can handle it a different way. You can tell me which way to handle it. I can meet with you on your schedule today, tomorrow, and then possibly cancel the building board appeal, which is what you're... And I got back. Thanks for reaching out this morning. I spoke to the municipal attorney about the request to meet. At this time, we are going to let the building board of examiner and appeals handle the matter. So you can't say both things. I mean, you can't get... But I mean, as an appellant, as a person trying to get an answer, I can't hear from both sides saying that type of thing. It's like a runaround.
I think I can, first of all, I would say, they didn't speak with, actually didn't speak with me, but
You should have.
Well, I mean, I can only do what I can do, and I get an email back from them, and that's it.
I think it's important, let me phrase it the other way. As far as being heard, I mean, I think that's fine. I need to make the objection that I don't believe that the remedy to be imposed, an order that says municipality, cut a check in this amount that we've determined, I don't believe that that's enforceable. I just don't think it is. And that we would, I mean, I'm not necessarily threatening or something that we're going to go to court. I think as an institutional matter, we'd probably be forced to take that to the court because it's not an express authority and it's a potentially dangerous one. And I've made the objection. If people are inclined to hear the appeal, I don't really need to argue this into the ground. If you want to hear it, I've made the objection for the record, and we'll just deal with it later.
Now, you're going to get off that easy.
I'm just suggesting that.
So you're suggesting, from what I'm hearing, that the appropriate process would be go through the judicial system?
Yeah.
Okay. Now,
Other staff says completely different thing.
They said we're not going to meet.
would it be
Now, they told me to go to the building board and have the matter handled.
Would it be acceptable to hear the complaints to determine if a refund would be legitimate without talking dollars, without ordering, but to verify the legitimacy of the claim?
I think we could do that. I mean, it might eliminate your problem of wouldn't the court just remand it, because then we'd already have a record of it. I don't think we have to do that. That'd be fine too. And we're ready to go forward if we need to. So,
Well, I don't want to, my question, what I'm trying to resolve internally is what can we do to be proactive but not cross the threshold that, you know, we've gone too far and the whole thing gets thrown out. That where I'm coming from.
But at the end of the day, whatever you guys do, the decision is made, both parties have the chance to appeal to the next level.
and that's
John's had his hand up. Let's let John.
My concern right now, after reading through it, and obviously might have the opportunity to learn a lot more when I'm hearing everyone's testimony on the issue, is I'm not seeing a consistent perspective on either side that's going to say this is the exact number, these are the numbers that are in play, this is the dollar amount. I think it's just going to be a specious argument of one side versus the other. And we're going to be left with making a decision of what? That refunds are due, and then who determines the amount? I've never looked at these research. I'm not going to state my reputation, and I'm not going to state my actions based on what's submitted here, because it just is not.
There's two topics in it too. so-
Hold on.
One, to just finish what I'm saying, Ron. So I guess my concern right now is starting down a path or a road that's going to lead to what? We're not going to be able to determine amount. I think at best we could say it appears that this needs to be discussed further and some resolution reached. But that's what I kind of sense right now, the best that comes out of this.
I tend to agree, but
I'm going to cut real close to where I'm seeing this. So the courts do, I think, would refer, and I can only say, think, there is inspections here that are noted, you look in there, time not tracked, and why Hanson's not doing that, and why we've spent a ton of time to do that, and why we can't go back to that. Super frustrating. But yet, then their side, this side. So those inspections, to me, I don't even feel like I can get into that. What I can get into, and what I think the courts would get into, is we can get to a dollar figure because there are inspections in here that were not used. And that's simple. And that's a cut, clean line that the MOA can see and we can see. The rest of the inspections of whether, but that is $1 amount you can get to quickly, and the courts would, I don't see how they would not go to that point. Now, the rest of it, whether and that's not the bulk of it. The bulk of it is on that, whether it was 30 minutes or all that. That's the bulk of, I think, the dollars. But absolutely, if these have been refunded by the city and we're not using those inspections, there's code that says refund the money. And I think that would stand up in court all day long. And I would, if you had my short answer, I would say that I would move to settle this to say, write that check. That would be an amount that we can get to. And the rest of it, I don't think there's enough. Yeah, there's both sides. I agree with John. I mean, man, well, back and forth, and then you look at all this. It was almost embarrassing to. And I'm not putting it on you guys, I'm putting it on Hanson. To fight through this thing as I've seen through all these years, and then not to have this stuff tracked. I mean, how in the world does that? They got a great point. They got an excellent point. But, and I don't know if it's completely provable because it's not. There's nothing written down. So I think there'd be fault on the city side of not being able to accurately understand when an inspection is started and stopped, and why that's not. There's a lot of wording in here that tries to build up. It's simple. I mean, an inspector gets in his car and goes to the next, and I'd like to ask this question too, but the inspector gets in his car to go to the next inspection, so that clock starts regardless of where he's at in town, because that's just a random circumstance. They could never start from one place. And then he drives that inspection and he does an inspection, and then when he goes to the next one, he starts the clock and he goes to the next inspection. And
It's not you too deep.
yeah, sorry.
Your particular.
We got to
Got down to, is it something that we can hear, and is it a decision that we can make, and what's the bearing on it?
Through the chair.
Russ?
Maybe offer a point of clarity.
One thing, well, go ahead, Ross, I think it's important.
I don't believe the appeal's over unused inspections.
Yes, it is.
I believe the appeal is over, the original appeal is only over the half-hour inspections. That's what the building official denied refunding.
I sat in a meeting with administration, told them exactly both cases, and on the spreadsheet, on every one of those spreadsheets, it totals exactly what the unused, non-paid back inspections were. And that's what's totaled here, and I have those exact numbers that you're talking about, because I agree at 100%, and I also agree with 100% on the other stuff. It's very much he said, she said. But part of this appeal has got what to happen. The new code got changed, and they've progressed to do exactly what you're doing, saying that. So to me, that's progress, and that's moving forward. And that's why I'm here, that's why I do what I do, and I do have the numbers, and I think that if you want to take the half-hour inspections out of the appeal, I'm probably fine with that, because they've addressed that, and they're doing it, and they're monitoring that now. But the other one, these people are either owed a credit on new permits coming in, or owed money for the inspections that were unused and not been paid for. And that's why I feel the case should be heard. And the attorney has told me this is the place I can go. I've asked many times, where can I go do this? And I was told this is the only route.
Through the municipal attorney's office.
Chris Schuete's office, who is the director, the head of this area, and he contacted the municipal attorney and he said it in his email, so.
Just, again, I don't want to belabor that point, but I think it's important to just make a record, if nothing else. My understanding, maybe we should make that email part of the record, but my understanding of that is that talking with Schuete was what was denied, and I think he's saying, look, this is on this Wednesday for an open process. Let's not on Monday or Tuesday or whatever compromise it behind closed doors. It's teed up for an argument. Go argue it. I think that's what it was, a denial of a meeting between the two of them. It wasn't the building board is the only remedy in the entire world to solve this problem. I don't think that was it. That was not a statement that you can't go to the court, the assembly. There was a denial of a meeting given that it was on for this hearing. That's my understanding of that advice from
So, I mean, let me just ask, if I was told to come to the building board to have the matter solved, and you're saying that you can't do it here, then what is that letter telling me? What is that email telling me to do? I have no remedy whatsoever. And, I mean, I'm appealing an administrative official's decision of Title 23 and the enforcement of the financial part of Title 23. That person has the right to make those decisions. They make it every day. They make that decision every day. So now, I mean, I guess I don't understand how it can't be heard, because it's not like it's a financial section in another title. It's a financial section in Title 23, specific to Title 23, specifically to that administrative official. And all I'm doing is appealing that denial, because I had no other course but to go to the administrative official of that title and appeal that decision. And that's what I'm here doing.
Sir.
I wanted to respond to Ron's statement about the unused inspections and the refund of the unused inspections. That was not in, it doesn't appear that it was in your original refund request. It's not.
It's an extra spreadsheet that you have in the documentation.
And it wasn't apparently, upon reading the letter from building official Sharon Walsh, denying the refund, it wasn't considered in her response. Her response clearly speaks to,
Now you're getting at why I'm so frustrated that it wasn't handled in,
I just wanted to put that into the record, that Sharon Walsh's letter speaks to the half-hour fee is not refund of unused permits. Unused
Ross, you had said that, and you kind of backed up what he just said, that there's no, you kind of say there's no appeal for the refund, you say we're not here for the refund. Do you guys agree that you'll give them the refund for the unused inspections?
Well, I don't know if we'll agree to that or not, but I'm just saying that that's not what the building official denied.
Okay. So whether you agree with it or not, code says if you don't use an inspection, you'll get a refund. Correct. So it's,
Yeah, we refund inspections all the time.
okay.
yeah, that's true.
So-
Not to everyone, though. Not to every single permit. They do some, it's hit and miss.
I think the municipalities didn't understand that that particular aspect of it was correctly teed up for tonight, just with the way the documents put out thus far.
We've got the authority here to speak for Sharon here, that, do we have a thing to hear right now, or is the municipality willing to, I don't know if you can say commit, but at least, seriously consider going through this thing and refunding for unused inspections?
Have you counted them? Is that how many there are?
I think you,
They're right there, if you want to look at it, for both contracts.
yeah.
I guess from our perspective, we just have to confirm that they were unused inspections and then,
I confirmed those numbers with Gretchen before I ever submitted for the refund.
And I looked through this pretty extensively. I believe that to be the case. Gretchen, is that true? I mean, is that confirmed that these?
And both companies have over the last couple of years. I feel that they have applied for the refunds in their writing, as it states that they have to apply. Also in the financial code, before any refunds can be issued, it must be completed and signed by the customer. We do let them know. If they choose to do it right then and there or send it in later, fine. But I do have a couple, going back to 2012, where they are aware and they have gotten refunds here from both companies and those employees who applied for the refunds and received them.
And those are the lists of the ones that weren't. So the ones that were, they were. Those are not.
And you confirmed that the ones that have not been paid for have not been paid back to them.
Yes, I sat on the phone with Ryan
Sure.
for a long time looking up all these.
Okay.
Yeah.
If you look at the list on there, it's way shorter than the big spreadsheets. So it takes out all the ones that were either refunded or aren't closed out yet, or all the different aspects that might be there. They're not huge numbers, but they're numbers that the contractor will do.
Isn't there a statute of limitations in the code that says you must apply for that refund within time X?
Let me tell you how refunds are given right now. If the clerk asks you at the counter when you're closing out, and you get your CCO, or you get your CO and you get a refund. If they don't, they don't. Several of those clerks, some that aren't here anymore, used to do that because there was a positive benefit for them on the backside.
To expire more than 30 days.
Well, that uses the term.
It's expired, these are not expired.
And
But that does not talk about closeout.
Correct.
Do we have a dollar amount on the unused ones? that-
10,950 per.
So 1,600 for MCN, they got more refunds and more closeouts. Criterion got way less closeout.
I've got, well, other way around, I've got 9,300 and
On Criterion.
1,650, which comes to a total for both of them, Criterion having the big portion, $10,950. On the permits that Criterion and MCN have pulled, and I'm not trying to bleed on their shoulder, but they do write a lot of checks around here. And whether they do or they don't, I don't even want to ask my question about what their permit fees. But in the last few years, so these amounts in here,
They shouldn't be part of
what they're compared to what that they, yeah, and that shouldn't probably be. But I'll get back to just that I believe that if we're in agreement, I can't be in agreement with the back and forth about the Hanson and stuff. I mean, again, I would say, yeah.
Do we have a case to hear?
I think we do, and I think it's easy.
I have one other question. Now we're starting to see these totals, which are the unused. And I guess my question at this point, I was hearing that to claim those, you have to apply in writing.
Yes, to apply,
And have
yes.
any of these been applied for?
No,
So,
I applied, that's why we're here. I applied for them last fall, last August. And I finally got a response in, last August, when I first started going to business and people started hiring me, I found out that they were not getting their refund and unused, and they said, it's like, we just send, typically they just send anybody over to get their CO. It's not a person that runs a project every time. So I filed for them, and then it took 8 months to get a response, or 6 months to get a response.
so again, I'm confused here because in just looking at this, the letter from Ms. Walsh appears to be speaking to denying the half hour. We're talking here the unused. Your original request, written request for itemizing all those is not in your packet.
It's in your package, it's the spreadsheets.
The letter is not in your packet. Your written request for the unused inspections is not in your packet.
Somewhat is.
It was submitted to the administration long ago on the refund form.
All I'm saying, Ron, is when you fill out your packet for an appeal, it's your responsibility.
I sent you those. She sent you all the spreadsheets. It's in every, if you have your spreadsheet, I'll show you.
Do you have a letter from your firm requesting the refund of the unused permits?
You put it on a refund form and you submit it.
Do you have it in your packet?
Yes. It was submitted they sent it back to me in her response letter.
Is this it? Is this your letter?
No, I didn't write a letter like that. It's a refund form. You have to submit refunds on a refund form. You can't submit a letter.
This one?
Yes, that type of form. And I submitted it as per the spreadsheets, and they called me in, and I had a meeting, and we went over all of them. And I said, unused inspections, we went over all of it, and the half hour, they disagreed with the half hour, that was fine. I waited and waited and waited and waited, and I finally received a response that just said, no, your entire request has been denied. That's why we're here.
Well, there's some disconnect, because the way I read the letter from the April 27th letter, it seemed to focus on the half hour.
So, Gretchen,
Did
you said that some have not been applied for. These are these speaking. He's saying that they have been.
they were applied for with regard to this submittal.
to this submittal, but in previous years, no. I have to 2012, what MCN and Criterion has gotten back from us.
But after that, it just stops. And it stops because
It goes up.
They still gave refunds throughout these years, just not these permits. They've done many more permits than this, many more. They just didn't catch, and you walk into the front counter and you hit a clerk. One of the clerk calculates it out, says, here's your refund. Another clerk says, geez, they forget, and they don't even ask the question. They close you out, give you a CO, and you walk out the door and you leave. You don't even ask the question. It just
It's not that simple, Ron. When you sit down with the tech, they go over, it's up to the responsibility of the contractor or the owner's agent or his representative to apply and sign the form. I just can't have Joe Smith representing Criterion or Jenny Rose Day signing those forms for the contractor. It states here in financial policy, they have to sign it and fill it out.
Obviously, when they're sitting there, I've done it many times in the last 6 months. Guess what? Here, you want to fill out the refund form? Yes, I get it, we get the refund. It's not, it's better than it
They're all
used to be,
different
but it's
people
not.
representing MCN and Criterion. They're all different. Very few are the same guy over and over. So they were all aware, I think.
The bottom line is, some were missed. That's money that's owed the contractor.
I'm not getting into it that far yet. I'm just trying to get to where you guys.
Can we make a motion to hear the case or not? We're trying to convene the meeting, so that kind of means that we're hearing it, and we've talked about it a bunch, so I guess I'd make a motion to hear the case. If I can even, I don't even know if I need to make a motion, do we?
Yes.
We made a motion to have a meeting, so.
Well, you just did the motion to hear the case.
Yeah.
Second? Guys, for lack of a second. More discussion necessary?
Well, again, I don't want to go too far down the road here, but it just seems to me from this go-round here that both sides recognize that there's validity in refunding unused. And so I don't think we need to be dealing with those. And so I think the matter can take care of itself with another round or another effort that fills out the forms and applies for the refunds to obtain the unused. Then what we have here tonight, and at least what's been presented, is dealing with the half hour.
I already said that I don't really care about the half hour. They've solved it now, they got it taken care of. I'm not a big, I helped write the fee ordinance. I know what the code says and the law says. I know for 100% fact that there's a lot of half-hour inspections. Without a doubt in my mind, without a doubt in any one of their minds, if they're saying there is enough, it is what it is. But to prove it, you know what? I agree. It's going to be tough. Hopefully now, they got that documentation and that it will be true, it will be real, and it will be fair for the contractors on both sides, because the contractors keep paying a huge amount of money, and at the end of the day, that money needs to go to what the services they get, and that's what it's all about.
And in follow-up, in Ms. Walsh's letter of the 27th, there's a closing paragraph that is speaking about the department in the process of purchasing a software module to allow field time stamping for inspection and performance time. And I have a note here that I was going to ask if that is being pursued, still on the table. Is there?
It is being pursued. It is, we are, Hans may be better able to speak to it. We are,
It's extremely difficult to find a software that actually can accurately do it.
Let me just tell you one thing.
Where you actually clock, every time a phone call, you push a button and it records it.
Yeah, but we get electronic inspection slips and give a date and time. I mean, cow.
The software does not currently, the software we have that Ron bought is currently not doing that.
We've heard that the software doesn't do this, and this. It doesn't do 7 years on Hanson.
It doesn't do it.
It's crazy. You get it? There's been a lot of, Ross, a lot of struggle.
Are you willing to submit paperwork to request refunds for?
Only for unused inspections, yes.
And is the municipality willing to consider those for further investigation for refund?
I'm going to say we're willing to consider them. I think we need to look at how timely they are, and how many of them there are.
It shouldn't matter.
Well, I think it does matter if it's a 4 or 5-year-old inspection and the permit's been closed for 2 or 3 years, and the onus, this is different, the code is different here, and the policy is different for unused inspections, in my understanding, than it is for the half-hour inspections. It clearly places the onus on a contractor to request a refund. The time of closure.
Well, see, this is exactly what goes on. They get at one piece, now all of a sudden they back down on another piece and they change the whole rules based upon a conversation. And that's the frustrating nature that's going on with this. And that's why I have not been able to get an answer, to get the right place to go, to talk to who I want to do. That's why I'm here. I'm willing to back off but there's a lot of information that I think needs to be public with regard to the half-hour inspection. But I'm willing to not say a word about a lot of different stuff to get this thing solved. Those are unused inspections, regardless of when they were done. If the code was there and said, this is what the fee is, and you were supposed to give them a refund for unused, guess what? In right-of-way inspections, it's been that way in Hanson from the day one that we got Hanson. So to say that it doesn't work in inspection, that's not because of Hanson. It's because of the lack of wanting to care about doing that and the lack of understanding exactly what the fees were set back in 2009. And that's the frustrating nature, because now we have a situation where we're willing to go after just the unused, and I don't even care if we get a refund. If we get a credit toward other permits in the industry, that's fine. But the problem ends up being is that's a lot of money for Criterion to just walk away from and just say. And it's not just those 3 years that I've fought, it's 5 years. It's been since 2010 that those fees are.
The onus of the contractor to be proactive in this. It's not the onus of the municipality to bring this to the contractor's attention.
The clerks count all the inspections at the closeout of the permit. That's who counts it, and that's who's supposed to know.
Apply. It doesn't say the municipality applies, it says the contractor shall apply. And so I'm not going to get into the middle of, how much time is reasonable time, but it is,
If you're told,
it is, got to be timely.
if you're told you have no inspections left and you don't have to, you don't get a refund, they don't tell you that. I mean,
If you
gotta walk through the
store and you don't get change, yes, you should ask for change, but you know what? Absolutely, they better give you your change.
Yeah.
I mean, I can see, I do believe that can stretch of time is tough. I do see though that he's still got a point. How many there are, I think if that's tracked appropriately, it doesn't matter how many they are. If they're unused, they're unused. That total, if it's confirmed, is some amount, then that shouldn't matter if there's 2 or 100. If they're unused, they're unused.
But Mr. Mossinger.
Sorry.
Okay.
Going back about 10 minutes ago to Mr. Steele's question, would you consider it? I think the answer is yes.
Yes.
That's what I heard. And I think we really, the municipality, didn't really think that question was squarely on the table tonight, so I think that Mr. Colby's saying we will consider it subject to, we want to think about it, is a reasonable answer. I mean, he's be careful and look at it some more. So, but the answer is yes, we'll look at it.
I mean, I'm hoping that's yes on another one that's going through the system now as well. They've been billing incorrectly for finished basements.
Well, let's not bring it.
Well, I mean, we're outside of a hearing and we're talking about getting fees correct. We need to get them correct.
So, as I'm hearing it right now, I don't think this is an action that the board needs to take, that this is something that can be handled administratively between the parties, and hopefully they can resolve that and come to some kind of consensus. I don't know, Mr. Steele.
So I was going to suggest this, that I make a motion that the building board does not hear the appeal this evening, and that on the basis of us not hearing the appeal, which we have heard opening discussions that indicate both parties are willing to evaluate the heart of the matter of the unused inspections, which were not part of the appeal, and the half hours, which are the appeal, are not being pursued by the appellant.
Said, well, they were part of the appeal, that's all.
Pardon?
They were part of the appeal.
But that's being dropped now.
Right, but I mean, I understand where he's going, but he said that they were never part of it, but they were.
Yeah, and it's hard for me, Ron, because all I've got is this form, and then the letter that succinctly is speaking to the denial. So I just don't have enough information, and the best I can glean from it is what I'm proposing.
Motion's made. Second?
Can you, so, I want to sum up here. Can I sum up the motion to make sure I can second it? Can you sum up the motion?
I move that the building board does not hear the appeal, and that would be case BCA 022016, based on opening discussions that indicate both parties are willing to continue discussion of unused permits, and the appellant is willing to remove any appeal associated with the half-hour inspections.
With second. I would really encourage, I was, the length of 124 inspections cannot be verified. That's, I mean, that's stuff that
There's an
you
awful.
don't want to, I mean, you read that and I go, oh man, you know, my mind goes from 80.
It also said 2 hours and 7 minutes for a
don't want to,
electrical roof inspection.
it just, I would encourage that, it sounds like this has been shored up a little bit more. And so I would just encourage that, because in the end, we need to use inspections, we want to get the right inspections. We want to have some sort of consistency, and I know that's being worked on, but we still do that. We get that inconsistency, and here's one prime example. I mean, that was a long time built up, but, you know, out of 210 inspections, 124 can't be verified. That's 50+%. So,
Can I say, so I share your frustration, honestly. We've been fighting this technology for a long time with it not being able to connect out in the field. So when you can't connect, you can't result, so you got to batch. I mean, it's been very, very frustrating. I've worked with Mobile Solutions, you know, we had weekly meetings, and I was the tester and trying to break it and trying to get it fixed, and we'd never gotten there, and it's been very frustrating. And you're right, it should be able to, with technology today, we should be able to track better. Currently, we're doing it manually. We're still not using the software. It's not, it has the...
First of all, let's vote on the motion, and then we can work on possible brainstorming of ways to solve solutions if you so desire. All in favor, say aye. Aye. Opposed? And abstain? Hearing none, motion carries as far as your motion to not hear. So, you know, now if you want to get into discussions on possible solutions, you know.
Well, I think just, again, hitting a couple of points that we should do in summary in support of our action is that there, though we didn't open it up, it was some healthy and good discussions on the issues, and the focus is moving forward in a positive fashion and manner, and the two sides will again discuss in more detail the unused inspections, and that progress was made without having to hear the appeal.
Go in.
We'll see if progress was made. Hopefully, I mean, the commitment. I mean, I work with these guys every day. I think they will, but I mean, I still have to point, my view is the fact that, you know, I don't think it's that hard to know whether inspections are half-hour or not. The reason fees were set the way they were, and I put my name on the line back in 2009 to argue for these larger fees for remodels, under the impression and under the agreement that they would get their money back if they didn't use their work. That's what the industry agreed to. That's why I got it approved and changed so drastically. The fees changed so drastically back then to do this because we were going into a very remodel environment in the municipality of Anchorage. And we were getting told constantly, when I say we, when I had my hat on at the municipality, we were getting told, $1 million projects are $200,000. And our fees were based upon the $200,000 and we're doing $1 million worth of work on these people's jobs. The whole point was to make it fair across the board. Muni would never lose money. It was never made to make the Muni money. It was to make the Muni not lose money. And that's what it was set up for. That's what it's trying to do. But if you look at it, if you look at right now, the 2 years that we're talking about, 2014 and 15, we're talking $10,000 here. The Muni made $2 million in 14 and over $1 million in 15. So just to tell you, it wasn't, the intent wasn't to go, yes, you have up years and down years, but at the same time, it was intended to not lose money. I think it works, I think it's there, but it needs to be fair, it needs to be monitored. And, on the out, I felt like I monitored stuff. I left right after that code was passed, so I left the building department, so I never was part of any of the enforcement. That might be why there was questions, because of the fact that, maybe they didn't understand exactly what I had set up at the time. But at the end of the day, I think the department does a really good job in what they do. I think they just need to sometimes, in this case, listen to me. They just wanted to say no from the beginning. They didn't listen about what I was saying, and that there was a whole lot of unused inspections. $10,000 of unused inspections, that's a lot of money. And to me, that was the bigger issue of why I really appealed this, was because there was just a blanket denial. It's like, that's our money, why are they denying it? That's why this appeal went on. That's why I requested the municipal attorney to meet with me this week and let me tell him that, because I couldn't get it any other way to say, let's not do the appeal, except have to put a case together to try to argue it. And obviously, we're all smart here. There's no way of proving the 50%, whatever it ended up being. That is what it is. But the unused portion is really what I felt was completely in code, very clear, and not paid back, and I think it needs to be, and that's the whole bottom, and hopefully I think that's what the discussion went into, and I'm fine with that. I think that these guys are fair, and they'll understand that, and they'll see it, and I think that I would hope that in the process that the money that I paid out of pocket to do all the research and try to do this thing would be refunded as well, but that would probably be asking too much, I guess.
If they don't give it to you, I'll give you $400.
It's 100.
His
I did research fees too.
That's research. Yeah, for the appeal, it's only 100. That's what he can get back.
Well, I'll give him the whole thing.
I can't. I give him the 100.
Anyway, it is what it is. Gretchen, do you want them individually, or do you want them all just in one big lump thing?
Individually.
Each individual refund for each permit that I want to refund?
It has to go downtown finance, yes.
Okay.
It's going to be by permit number, so they can't.
So what you can look is that list. I'll give that, I'll take that list back and I'll just turn those in next week. And we'll see what
I
happens.
think you got pretty good argument going on the unused ones. The half-hour ones, there's a lot of circumstantials that neither side could move, and I'm looking at it from the judicial side, what would a lawyer say?
No, it's,
That's the thing. You can't say they do 12 a day, so that's average of 45 minutes and that, that would work.
you just got to remember, remodels are, some are big, some are small, some are half hour, some are less, some are more. The routes of inspectors, they're supposed to be in little pod areas to keep the drive time down. If you look at all of those scenarios, there's just more than zero, right? No matter what, there's more than zero half-hour inspections. And that's, it is what it is. We all know
I hear
that.
that the municipality is making direct, positive steps in that direction to better account for that. Mr. Steele?
One thing that I would just throw out as a comment, and I may be over my head relative to this, but some of the presentation in the packet was talking about the timeliness, and that has come up also in terms of the evaluation here. And the only thread I've seen leading back to is this link to the fee refunds and the term expired. And so I think this is something that may be something that is worthy of conversation of maybe this needs to be modified to include project closeout or a time frame following project closeout, so it's fully understood. And so it's not open-ended. I know from dealing with my parents' past taxes with the IRS, they have a 3-year moratorium, and beyond that, if you didn't get your money back, that's too bad. So I think there are ways of, maybe that's something that the administration would want to advance some language changes to be a little clearer on that.
I agree. We're thinking 30 days. Just kidding. No, we definitely, I think, we do need to clean that up.
Mr. Logan.
So, Candy, you've been building official. Do we have any down the road plan? Is this permanent? Is this temporary?
Oh, for me?
Yes.
This is temporary.
Temporary.
I'm saying,
Do you think interim?
I kind of got that, but I was hoping that maybe he would have just said, I'm going to be here for 4 years.
Or 5. I thought maybe there was a sigh of relief. No. Yeah, my permanent job is the engineering manager.
So how is the search, and obviously that's appointed by the mayor. I'm sorry, I'm really dumb at this, but
It's a mayoral appointment.
so is that just however long it takes to
I think it is the mayor has not consulted me on
Okay.
his plans.
So they assure you they're aggressively.
Just to let you know, they've notified the home builders, us, to give them names. So they want names, so if you guys know names, I'm sure they're looking for possible people. They're looking for people that might possibly be interested. So we've been, as a board, we've tried to throw some names in the hat toward them, but we haven't heard anything.
Second question, is my understanding of the inspection start-stop time with the travel? You said you've got that kind of figured out now. Where is that landed as far as, I guess I know there's pods of town, but how's the start and stop time? How is that? What is it?
As soon as you leave the inspection, or you finished the inspection one place, it starts a new one.
Yeah, good.
Until you finish up the next inspection.
And no matter where he's at, if he's zone on the other side.
How many inspections a day are they averaging these days?
It really varies from day to day.
I know, but what is the...
10, 7, it really varies day to day. But with manually doing everything and all that, we lose an inspection a day.
With the tracking of the
With tracking
inspection
everything, we lose
times.
an inspection a day.
I can
For the inspector.
Mitch some kudos, he seems to be doing a really good job of being lead structural and trying to.
So you may or may not be aware, Mitch is now he was the acting lead structural inspector as of Friday, last Friday, Monday. They're all acting. He's the permanent. Yes.
Phil accepted it.
I just didn't, it wasn't towards anybody, it was just another one, when we went from, longevity is good. I mean, it gives relationship, and so everybody, Jim was there for a long time, and then, it just kind of got rolled around. I just didn't want to see it get rolled around again, so I'm glad Mitch has got it, and I think that I just give him a little kudos. I think he's doing a good job.
The entire, all the people that I'm working for are saying the same thing on the inspection side. They've been very pleased with everything that's
I don't
going
know
on.
all what he's doing, how I'd say it's, we can see it, feel it. We don't really know all.
We'll pass it, Hans and I will pass it on.
They email, they call. Every time I put in a request, you get the call ahead of time to be there. Everything has been really good. And I'll just test out the half-hour thing on my two that I got on my building, because they both said they were under 30 minutes, so we'll see if they were. I asked
That
him.
30 minutes does not just include includes prep time and all that.
Yeah.
And you do a phone call, it costs you money. You chat to the inspector during the inspection, it costs you money.
If you don't get an inspection, it costs you money.
Say the same.
If you cancel it, I was just
If you cancel the inspection, the inspector is on site, it'll cost you half an hour.
Yeah, any cancel inspection should cost you, I think, $125.
Not if they cancel it before anybody leaves or anybody has done anything.
Yeah, I don't,
So if you're canceling, I guess, and nobody gets there, then you don't pay, you're not paying any.
But once you show up, you've got at least half an hour.
You got at least half an hour.
And Gretchen, you're fully staffed now almost? Just
I am.
training now?
How many permit clerks?
5.
Remember when Gretchen first started? I do.
I would make a motion to close the meeting. Any second?
No, that was it. Second. Stand adjourned, thank you very much.
private development, generally.
So, why sharing a different department, or?